Yeah. Thank you again for inviting me to be on this talk. I will be talking about native customary rights over land in Sarawak, Malaysia. My name is Simon. I'm a lawyer by profession, and I practice here in Kuching, Sarawak. So to start, who are the natives of Sarawak? So under the Sarawak Interpretation Ordinance, there are about 20 ethnics that are considered as native in Sarawak. So there are two famous. The one that is most well known is actually the Bidayo, which are the land Dayaks, or the Ibans, which is called the Sea Dayak. So after this, we will hear more of these two groups. So what is the native customary rights of a land? So NCR lands are actually lands that have been occupied by the ancestors since time immemorial. So even before the groups came, so even before the Brunei Sultanate, the NCR land has already been there. Those lands that has been occupied by the native of Sarawak by the ancestors. And normally these lands, they have territorial domain, which is first determined by the ancestors. So during the older days, there are even punishment if people trespass into a boundary that if it is not from your own clan. And one of those punishment is even death. So NCR normally, the benefit, the use of NCR is actually for their livelihood, and it has cultural and spiritual connections to it. It is in the forest that they actually hunt for food, they fish, they look for jungle produce. Since time immemorial, they have been doing this. They even have a spiritual connection to the land. Some of these NCR land, they actually have big rocks, which are considered as sacred. Within these big rocks, they actually considered to have spirits to be placed where the ancestors will rest. So these lands have so much spiritual connection to it that the native respect them. They have reverence to them. So if you can see here, some of them they actually use for hunter gathering, and they will make jungle produce out of it. They will make houses. They will make boats as well. And this is the main part of our discussion, our talk today, which is the land, the law of Sarawak over NCR. So the main law that is governing NCR land is actually the Land Court of Sarawak. It was passed in 1957 and come into force only on the 1st of January 1958. Not to say that prior to this law, there was no law in Sarawak. Prior to that, actually, the Brutes and the British, actually, they have several other laws. They are called the Raja's Order. They are called the ordinances by the British. But none of them has actually dealt sufficiently on NCR land per se. Even if there are some laws that deal with this, they talk about Temuda, which is land that is to be land that has been cut off when the tree has been cleared. So in the Ibans, the native Ibans, these are the terms that we will use continuously later on in our talk, which is very important for you to understand. The Pemakai Menua is what the native call as a territorial domain. A territorial domain is like a boundary. It's like a land with a boundary. It's just like when you consider Tokyo and Kyoto. Those are two different places. Under the Tokyo, you have a mayor. Under Kyoto, you have another mayor. So it is that kind of situations where the native in Sarawak, back in the days, they already have this kind of boundaries to divide themselves between communities. To come into each other's land, they actually have to get permissions. If you take something from another person's land, there is actually punishment. So within these boundaries, within this, let's say within Tokyo itself, you have a Pulau Galau. Pulau Galau is the reserve forest. So back then, long time ago, they already have this idea that we should conserve forests, we should reserve forests for the use of future generations. The native always say it is stupid if you cut down everything, because if you cut all the trees down, then you have nothing left for the future generation. You have nothing left to hunt. You have nothing left to gather from the jungle. You have no more fish to fish. So that is why in the minds of the native, even before Brooks, they already conserve forests. And forests to them is so important. They have been conserving these forests for the use of future generations. And the last one, the Temuda, which is land left to fallow or farm or cultivated area. So the only area that they actually totally cut down the trees, are the area where they settle down, where they build long houses, where they build the graveyard, where they build, where they go and plant rice or trees or fruit trees. Those are areas they consider as Tomuda. And within this whole Pemakai Menua, sometimes, most of the time, you will find a place specifically only for graveyard, which they call as Pendam. So I make this very simple graphic. So these blue clouds here, this blue clouds is considered the territorial boundary, which is the Pemakai Menua. So everything within this Pemakai Menua belongs to this community. Let's say Simon, I'm the chief of this village. So this area will be considered as area that falls under Simon. So no one else should come into this land without my permissions. So within this Pemakai Menua, you will have the reserve forest. Normally the reserve forest will be very, very big. So it will be very big. The whole area, most of the time, it will be covered with reserve forest. Whereas you will also see a small area which is a cleared land. Normally we will color in yellow. It's called the settlements or the plantings area. And normally they will also have a graveyard in the Pemakai Menua. And the graveyard normally, sometimes it will be far away, sometimes it will be very near. But from, let's say, from this area all the way to the settlements, according to the native of Sarawak, the distance between this one to this one will never be more than a half-day walk. It will not be more than a half-day walk, because the logic was, if let's say they go all the way here to hunt, because they cannot go outside. The moment they go outside, it will be another community already. They will come here and hunt. Once, let's say they hunt for wild boar and they manage to hunt the wild boar, so they need to bring the wild boar back within half day's walk. So they go and hunt half day, come back within half day. So this is one of the way they can claim NCR land, but it may be differing to some other ethnic community. So under the Sarawak Land Code, under section 5.1 and 5.2 of the Sarawak Land Code, NCR can only be created. You see, there's a cut-off date. It's on the 1st of January 1958. If you can create NCR land, if you fell virgin jungle, you plant lands with root trees, you occupy it, use of land for burial grounds, use of land of any class for rights of way, or any lawful method. Pemakai Menua, our argument is that Pemakai Menua and Pulau Galau comes under this section 5 to F, which is any other lawful method, because this is part of the other. So after the 1st of January 1958, NCR may be created over NCR may be created, but you have to apply for permit under section 10 of the Sarawak Land Code. But generally, we don't really see this, because back then the natives are not informed. They do not know that they can apply under section 10. So most of them, they never apply. So there is no section 10 land in Sarawak. So prior to the coming into force the Sarawak Land Code, like I said earlier on, there has actually been a lot of laws already. The natives are actually free to roam within their NCR land. And we have cases where the residents is like the mayor in the district back then of the individual district knew of the boundaries of the native. And they are the one who will become the judge or the mediator to resolve territorial dispute. So some of the punishment that if people make troubles within the districts, so they will actually take away their valuables like gongs and jars. Some may be even asked to move away to another district altogether. So the legal status of NCR land, native is deemed to have, even though they in NCR land, normally they don't have title, they are not given title. But this under section 5 of the land code, the native is deemed in law to be a licensee over the land. And the rights to use the land is supposed to be protected by the state against the trespassers. But a native is not just a bare licensees. It means to say that they are not just normal licensees, because under section 5, if NCR is extinguished by the ministers, the native must be compensated. So if land are given away, it must be compensated. And secondly, under section 15, land cannot be given, and the land cannot be given to another company until NCR has been extinguished and compensation is being paid. So if there is NCR over the land, it is the duty of the government to go and do a survey and to make sure that the land is extinguished first before you give it out to another company. Extinguished and compensation must be paid before the land is given to companies. Let's say the government wants to give the land for timber or palm oil plantation. So what the government must do is go and do a survey over the land, make sure there is no NCR land. But if there is NCR land, they must extinguish first and then pay compensation. Only then you can give out the land for timber license or provisional lease for palm oil plantations. The last one is under section 18. If the government can give them individual land title if they apply through the land and survey. But generally, this is very rarely given and only given during election times. So it is not the best of way. So like I said earlier on, when native rights are to be extinguished by the government must pay compensation. So no state land is encumbered by native customary right may be alienated without payment of compensation. But the reality of claim over NCR land is that the burden is always on the native to prove their claim. And the state government position is that the government only recognize the Temudak land, the area that has been cleared before 1st of January 1958. But the native consider the NCR land to not just be the Temudak. The Temudak cannot exist without the Pemakai Menua and the Pulau Galau. So the Pemakai Menua have to exist first with the Pulau Galau and only then the Temudak. But the government only recognize the Temudak. Because of these differences, then normally all these cases will come to court because there will be conflict, there will be disputes over what is considered as NCR land. I show you this. This is an aerial photograph. Before the British left Sarawak and before Sarawak get independence, the British actually take aerial photograph all over Sarawak. They took aerial photograph all over Sarawak in the 1950s until the 1960s. So there are actually two rounds of this. These documents, the state government consider it to be restrictive. So it's only able to be found in the state government. But if you go to the archive in Bristol, in the Bristol Archive, United Kingdom, they actually have all of this as well. So I'm showing you an example which I used in one of my cases. This is given by the government. So this is what I was telling you just now. So the area in red here, the area in red is the area that is given provisionally for palm oil plantation. This is the area that is given palm oil plantation. Whereas the yellow one, all these yellow boundaries are land that is claimed by the native. The government position on this is that only this area shaded in yellow, which is considered the cleared land, are NCR land. All this land that is in green, which is actually Pulau Galau or reserve forest, are not considered as NCR land. So the government said we are only recognizing this area in yellow, not this area in green. So that is where the dispute always arises. So that is why the government said, no, we are not going to recognize the area in yellow. But in the year 2001, the case of No Anak Nyawai against Borneo Pulp, the High Court actually says the common law respects the pre-existence of right under the native laws and customs. As long as it is a law and customs of the native, the common law respects the pre-existence of this right. It means to say, Pemakai Menua, the territorial domain, and the Pulau Galau, the forest reserve, are NCR land and they have the force of law. So the government must recognize it. So the native NCR land does not owe the existence to statute because it was there already, even before the government was formed. So the Sarawak Land Code does not abrogate, meaning to say the Sarawak Land Code does not destroy, does not delete NCR land that existed even before the Sarawak Land Code came about. So after No Nyawai, there are actually many cases that we have won in court. The court recognizes that Pemakai Menua, Pulau Galau, Temuda are all NCR land. So I'm showing you one of the case that I did as well. This is a case against Ta'an. This is in Ta'an in Bekenu area, Bekumah area near to Balingan. In this area, in this case, we actually won 450 hectares of NCR land over land that was given by the state government to Ta'an to do logging as well as planting palm oil plantation. Even though after we won the case, but because this happened in 2015, in 2016, the Tuan Rumah Sanda case came. So because of that, we had to actually eventually come to a settlement with the company because we were worried that we will lose the whole case because of Tuan Rumah Sanda. And I was talking about No Nyawai, despite the court already making such an order that Pemakai Menua, Pulau Galau, and Temuda has the force of law, but the state government continues to ignore the court order and continue to give out license, to continue to give out timber license, provisional leases for palm oil plantations. And some of our people, some of the native of Sarawak have to go through, were arrested for defending their land. This guy in orange shirt, his name is Numpan Suntai. He was working in a oil company, in oil and gas company. But because he came back to defend his land from logging from one of the Thai Mammoth's company, Quality Concrete, he was arrested, even though on the day of the event, he was not there. The police arrested him, even though he was not there. Then we have another friend of ours, his name is Suri Anak Muntai, who was defending his land, and he was beaten up. Not only was he beaten up, he was, they even used a samurai sword to actually go and assault him. He was badly injured. You see the hand? He was actually chopped off his hand here, but he managed to fend them off eventually. And we have done protests. This is protest done in Miri town. It is in Miri town that we have done this protest back in 2015. And until one of my friend, Bill Kayong, was murdered for defending NCR land. He was shot in broad daylight inside his car at a traffic light, and he was shot in June of 2016. We continue to do our protests, and this is in Kuching Alcock House. We continue to do our protests even after that in 2017. And there have been petitions. We have been trying to petition this for a very long time. As you can see, Mate is standing here, one of my good friends here. And the most disappointing case is, in fact, this Tuan Rumah Sanda's case. Despite so many successes from No Nyawai in 2010 all the way until 2015, despite so many successes, so many courts that have decided that Pemakai Menua, Pulau Galau, and Temuda is NCR land, Tuan Rumah Sanda eventually overturned the whole decisions and said that there's no Pemakai Menua and Pulau Galau, the territorial boundary and the reserve forests have no force of law. He said that the law only recognized the Temuda, which is the cleared land. The decision actually tilted to because Abu Sama decided that there was no sufficient evidence, which we said that is actually not true, because in High Court and the Court of Appeal, the court actually says that there are enough evidence to show that they have NCR land. But the best decision actually comes from the dissenting judgment of Zainul Ali. Zainul Ali actually says that the custom of Pulau, which is the reserve forest, is a native custom so intricately tied up with the virgin forest within the Pemakai Menua. He said here, Temuda exists because it is part of Pemakai Menua. You have to have the Pemakai Menua to only have the Pulau Galau and the Temuda. So to disembody Pemakai Menua and Pulau Galau from Temuda makes little sense, because you have to have the Pemakai Menua to have the Pulau and the Temuda. Without the Pemakai Menua, you don't have Temuda. So after the decision in Tuan Rumah Sanda, the state government, who has for many years opposed the native in recognition of the NCR land, finally recognized NCR land for the Pemakai Menua, Pulau Galau, and Temuda. They introduced this Section 6A of the Land Code, where they finally recognize the pemakai menua or the territorial domain is being recognized. But the problem with Section 6A, I would say this, the problem with Section 6A is that up until today, it has not, I have not heard of anyone land being applied under 6A, because you need to first apply, the native need to first apply, and it is the discretion of the land and survey to accept or reject. And you can only appeal to the Director of Land and Survey. So meaning to say the native go and apply, it can only be appeals to the Director of Land and Survey. And the land limited is only 500 hectares to a maximum of 1,000 hectares. This will definitely become a problem, because the territorial boundaries that they are going to recognize are not according to the one that is set by the ancestors. The ancestors could have set a bigger area, but you can only allow to have 500 to 1,000 hectares. So, and also there's no clear application. How do we apply this? There's a village in Kampong Rayang in Serian. They have like 6 villages together. And that area, they have about 2,000 hectares of land. So it is 2,000 hectares of land. So which part of the land are you going to cut off to be included into that 1,000 hectares of land? And imagine if you have like 6 longhouses. So how are you going to divide this 1,000 hectares of land to 6 longhouses? So is it one longhouse, one application, or multiple longhouses with the same ancestors in one application? So the land, if the land is beyond 1,000 hectares, whose land is going to be included and whose land is not going to be included? But after the Tuan Rumah Sanda's decision, we managed to found another case called Tuan Rumah Ramba. Tuan Rumah Ramba in Liam, in Miri, in September 25th, 2019. But then, even though we have this case in the federal court, the case was already heard on the 10th of May, no decision coming out yet. We are not sure whether, even if we win this case, whether it will affect all the future cases or not. Because even after Tuan Rumah Sanda's was decided, a lot of the federal court judges, they don't agree with the Tuan Rumah Sanda's decision. A lot of them don't agree. That is why the Tuan Rumah Ramba case is still alive today. But we are worried because of the new law under 6A, whether even if we recognize pemakai menua Pulau Galau and Temuda under this case, how is the new law going to affect future cases? So in fact, if the cases that we have found in court, we have more than 200 cases. We do not have the official statistic, but as our record shows, we have more than 200 cases. It could have been more than 400 cases as well, depending on those cases that may have been found and lost along the way. And we actually made reports to the Malaysian Human Rights Commissions, and they actually came out a report of the National Inquiry into the Land Rights of Indigenous Peoples. And they have a lot of recommendations, but so far the state government has not taken the recommendation into account.